Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Happy Sunday to you all. ఈ రోజున మనం చర్చించబోయే విషయం లా ఆఫ్ టార్ట్స్, కన్జ్యూమర్ ప్రొటెక్షన్ యాక్ట్ అండ్ కాన్స్టిట్యూషన్. ఈ మూడిటికి సంబంధించినటువంటి చాలా ఓల్డ్ కేస్, 1998 కేస్. లా ఆఫ్ టార్ట్స్లో దీని గురించి ఫస్ట్ సెమిస్టర్లో చెప్పడం జరిగింది. దీంట్లో ముఖ్యమైన పాయింట్ ఏంటంటే వెదర్ confidentiality clause can be broken or not. ఎందుకు? Whether the information that a patient is having HIV can be disclosed to his relatives or not, or to the third party or not. This is the question. Supreme Court said yes in public interest. Second point, right to privacy is not an absolute right. So, వీటన్నిటి యొక్క సమాహారమే ఈ కేసు. The case law is Dr. Tokhugha Yeptomi. Dr. Tokhugha Yeptomi is from Nagaland versus Apollo Hospital Enterprises, 1998 case, in which two judges bench, Justice B.N. Kirpal and Sagir Ahmad. They held that in this case, the prospective bride was saved because of the information given that Tokhugha was infected with HIV. So let us not repeat the names for so often because I don't know whether they are alive or not. It's not better. It's not good. No doubt it's a reported case law. He is also a doctor. He is working. He completed his studies in Chandigarh. He was a postgraduate. Ultimately, he joined Nagaland service. And he was asked to accompany a patient in the year 1995 from Nagaland to Apollo Hospital. Her name is Itoku Yeptomi. Brought the patient to Apollo Hospital, Chennai, because it was the actual corporate hospital, first best hospital at the time. Of course, now Apollo Hospital is there everywhere. Then there was a necessity to conduct surgery for the so-called Itoku Yeptomi. The doctors, they said they are in need of blood. The patient needed blood. And Tokhugha came forward to donate the blood. His blood was taken. But before transfusing the same, they tested and found him positive for HIV. Finish. They found him positive for HIV. Immediately, they informed him, and the problem is, they informed the patient. ఎవరికైతే ఆపరేషన్ అతను కూడా చెప్పారు, వాడి బ్లడ్ పనికిరాదయా, ఈజ్ హ్యావింగ్ HIV అని వేరే వాళ్ళు బ్లడ్ పెట్టారు. ఓకే, ద థింగ్ వెంట్ ఆన్. సర్జరీ అయిపోయింది. ఈ వెంట్ బ్యాక్ టు నాగాల్యాండ్. కానీ ఈ పేషెంట్ ఇతోకు యెప్తోమి ఉన్నారే, వీరు publicized the matter in such a way among the community that he is affected with HIV. Result, the prospective bridegroom, అంటే అతనికి పెళ్ళి ఆ పెళ్ళి ఆగిపోయింది. Why? Because the parents are the relatives of that bride. They came to Chennai. They asked the hospital management about the health condition, about the blood. In the beginning, they refused, basing on the confidentiality clause. Normally, the patient or his own relatives or his wife can be informed about the status of the so-called HIV. Right? Ultimately, they are said that the prospective bride, they are going to give her their daughter in marriage with him. So then they disclosed that this man is affected with HIV. Marriage stopped. Will Dr. Tokhugha keep quiet? Yes, he filed a case before NCDRC, National Commission for Disputes, National Consumer Disputes Redressal Commission. Of course, they also did not agree. So in general interest or in public interest, the confidential clause can be broken, like that they have written. The matter went to the Supreme Court. Supreme Court also stated the same thing, that right to privacy, no doubt, privacy, secrecy should be there, but the fundamental rights are not absolute rights. They have got reasonable restrictions. So what are the reasonable restrictions? This is what I am going to tell you. They have explained in the Honorable Supreme Court of India. 6 points will explain this. Now let us quickly read one by one. Number 1, protection of the life of others, protection of the health of others, protection of the moral society. For this purpose, definitely the confidential clause can be waived, because wife health is more important, What happens, suppose if she is not told, she will be affected with HIV, the children may also get affected. Second point, if not already, the wife would have been affected with HIV. Third point, right to marry cannot be enforced when this man is suffering from the communicable so-called venereal disease. Fourth point, the person suffering from virulent disease, so he should be banned from marriage. He cannot go for the marriage. Fifth point, when there is a clash of two fundamental rights, one is confidential clause, one is right to privacy, second is right to life, right to health, right to morality. Right to morality, of course, we cannot this thing. So, if two fundamental rights are clashing with each other, the advantage should go to the right, which advances public morality, and it has to be followed. The public morality should say that yes, this man he should not be allowed to marry that woman. Last point, that is sixth. Doctor can inform third party when there is a serious identifiable risk. Suppose if he doesn't inform anybody, then simply he will get married and the problem will come. So therefore, the doctor is competent to inform the third party or to inform any other person about the risk involved, because it is a communicable risk. Straight away atanu effect అయితే పర్లా, అతని వల్ల మిగతా వాళ్ళకి అవుతుంది. So kabatti, yes. So it's not a case of confidentiality clause. It can be waived. It can be broken. అది ఈ కేసులో చెప్పింది. అక్కడ 2 ముక్కలు చెప్పాను. ఇప్పుడు నిన్న ఏదో కేసులో చదువుతూ ఉంటే కనపడింది. అందుకని మీ అందరూ బాగా అర్థం చేసుకుంటారని చెప్పి I think I have explained in detail. Thank you.